Well, the first arrests under the state government's new anti-bikie legislation came today. 2 men were detained at the Odin's Warriors clubhouse in Cairns and charged with being part of a criminal organisation and entering a prescribed place. They're now facing a minimum 6-month jail term. Again this week, we asked the Premier and the Attorney-General to talk about the groundbreaking laws, which include mandatory sentences of up to 25 years, but neither accepted our invitation. I was joined in the studio by the President of the Queensland Law Society, Annette Bradfield. Annette Bradfield, some significant legislation relating to bikies this week. Some say watershed legislation. What does the Queensland Law Society make of it?
It's been an extraordinary week in Queensland. The Queensland Law Society is concerned about the rush on some of this legislation and the lack of consultation.
You had a policy team looking at the laws. What particular problems have you highlighted?
With the legislation dealing with the sex offenders, there's a concern that it can't be redeemed, which is quite extraordinary. Normally, there's an opportunity, I suppose, to make amendments to overcome some of the unintended consequences of the legislation when it's been rushed through.
The sex offenders legislation?
Correct.
So what kind of unintended consequences would mean it's irredeemable?
It's irredeemable.
Like the whole thing just needs to be scrapped?
At preliminary review, that's the case.
So what could be salvaged? Can, for instance, the Minister, the Attorney-General, wants to have the power to indefinitely hold someone in prison. Is that able to be saved?
We, of course, want to ensure that the judiciary retains the role of making the determination as to who stays in prison and who's released. But there would need to be significant amendments, and we think probably the only way you could do it is to rewrite the amendments that have been put through Parliament this week to try and capture what the government is wanting, but take into account some of the concerns that we have.
Just going back to the bikie legislation, you said you were surprised at the rush. Why do you think they went through so quickly, and how much kind of consultation do you need to get these kind of laws in?
Well, firstly, we already have laws that apply for the circumstances they're talking about. We've got the Criminal Code and other legislation that deals with these types of things. Secondly, consultation with all stakeholders is necessary to ensure good laws are made. And given that there's no urgency for the laws, we can't see why a couple of weeks couldn't have been allowed to the stakeholders to comment on that legislation. And we're also concerned that what we're creating here is this unusual situation where we've created law for a minority group. And where is it going to stop? Are we going to see more laws being drafted just to deal with specific groups or specific issues? And it's a very slippery slope.
I noticed that there's no word bikie in that actual legislation.
Correct, and that's one of the issues. It's being referred to as, the bikie laws, but it's not restricted to bikies as we know them. It can be to all, manner of groupings of people, sports associations or whatever, if it can be shown that there's a criminal intent for that group.
What about the penalties? Do you think 15, 25 years, is that proportionate to other legislation?
Well, the issue is it proportionate to the crime that's been committed? And the issue that we have is that the judiciary no longer have the power to determine that. And it's appropriate for the judges to make that determination because they know all the facts and circumstances. The legislature is there to make the laws, and the judges are there to apply them, to interpret them. It's all about the separation of power.
Well, I guess this also applies to the sex offender legislation that was introduced this week, which we'd already just touched
Correct.
on. The Attorney-General now has the power to hold someone indefinitely in jail, and you can't appeal to the Supreme Court. This obviously raises that question again, doesn't it?
It's exactly the same question. The judges have all the facts and circumstances before them. Sometimes they're facts and circumstances that you and I don't know about, and that's what we always have to remember here. They're best placed to make the decision as to whether that person should remain in prison or should be released.
Are you surprised that a government in Australia or a Western government would disregard what is a fairly recognised doctrine?
Correct. It's very surprising. It is a fundamental principle of our democracy. It's applied in Queensland for a long time, and it's like going back to our colonial days.
All right, Annette Bradfield, thank you very much for coming in.
Thank you very much, Matt.